I think what I'll leave is gonna be the comparison with the laws in other countries which are there in this presentation. So that we can do after this one. Baki sab to I think I have covered here. We'll actually go to the OTT rules and see what's there.
We can do that. Why don't you begin and then we can take it from there.
Right. Can I see everyone on video, please? I think we have sufficient people in the class. Shanmugam ji, Rishi ji, Kavita, Sameer, everyone on video, kindly. Okay. So what I'm presenting, sir, today is this case, very important and very famous case, Antony Clement Rubin's case. So what this is about basically is this is a tussle between the state and some of the other foundations and the social media giants, wherein the state is saying that we want access to all the data that these OTT platforms have. And these OTT platforms are saying that we cannot compromise the security of the users that we have. The users, on the other hand, jinko represent kar rahe hain, they are being represented by some people, some trusts and organizations like Internet Freedom Fund, and there's another freedom organization. They are saying that this should not happen, and they are pro privacy. The state is kind of anti privacy, but they have a logical point also, because they come with the objective that they want to prevent cyber crimes and they want to make the investigation more efficient. So this is what the scenario is. There is one person called Antony Clement Rubin. This person is in the southern part of India, and there is one festival called Jallikattu there. And in that festival, what happened was that something happened with the animals that are used in that festival, and there was some violence that took place. After that, this person, Antony Clement, who's a activist, who's an animal rights activist, he was conducted into a committee for the investigation and for how Jallikattu has to be organized from the year onward, and what all measures should be taken for the animals and all that. So now this person has been just a second. Yeah. So this person now has been inducted into a committee, and he's sitting across on the table and he's talking and everything, and he suddenly starts receiving threats from all over the southern part of India. He goes to the police station, he files complaints and everything, but to no avail. The police is not ready to help him, and out of the 3 complaints that he filed, one police station or one investigative agency was ready to help him, but they could not, because they did not have the means to do it. So this person, because of these threats, got disturbed enough to file a case in Madras High Court to ask Madras High Court to order that all these organizations, Facebook, WhatsApp, Instagram, Twitter, everywhere that he was receiving threats and messages from, these were threats to him and his family as well. So whoever is sending these threats should be identified, and how that can happen is these organizations should allow the linking of Aadhaar card with the profiles of all the people on social media. Now, this was not a very comfortable engagement for the social media giants, of course, like Facebook, WhatsApp, and all that. And for other people, Internet Freedom Foundation, and obviously the users, is not a very comfortable proposition. So now what happened is this case in Madras High Court started, and the Aadhaar organization also came into the picture. they also suggested that yes, we should link Aadhaar, because in today's time, data is the new oil and they're all about data. So they were like, yes, let's connect everyone with data. Ministry of Electronics and Information Technology, they were not interested in doing this because they knew that this is overstepping. But they were made a party, so they were obviously in the uh, this they were in this team that yes, let's connect, but we are not very sure about it. Aadhaar organization was pushing for it. Rubin was pushing for it. But on the other hand, social media giants, Facebook and other organizations were against it. Now, the contentions that were raised by social media giants were that one, it's going to be overburdening. Then it's going to become very hard for other social media organizations to enter India, because it's going to be a lot of uh, curation and a lot of oversight, a lot of control mechanism that they will have to put in. Then it's obviously going to be harmful for the privacy of the users. Then um, okay, and then Facebook also came into the picture, and it said that it is about how far we can go into protecting the privacy when the state who is the who has to represent the people, they are not allowing us to do whatever we can do with our tech. And you are saying that let's get into the privacy, let's get all the numbers linked and everything. So we are stuck between two people. One, the state who's saying that we want it linked and we want all the data, and then there are users who are in magnificent numbers who want that they should never be, their privacy is of paramount importance. Now, after Madras, there came another case in the Tamil Nadu High Court. Another party came and another party asked for these social media organizations to be, ordered to help the investigative agencies to give them the decryption key, because WhatsApp is providing us encryption, encryption to encryption, end-to-end encryption, and these people have many, technical stuff going on which protect us. They even cannot get into the privacy because it's end-to-end encrypted, and we are the only ones who know what messages we are sending and receiving. So in Tamil Nadu, another case was filed. So what they said there, the government said that if there's a lock, there has to be a key. So you provide us that key and we'll be able to do it. Now, Facebook and everything, there are very, very popular lawyers in these cases, like Sajan Puvaiya sir. There is Mukul Rohatgi sir. There is other, there was Sibbal. Mr. Sibbal was also involved. So big shots were here, and they were giving fantastic arguments. If anyone wants to read the complete judgment, you'll find very good material here. A lot of literature was used and a lot of good stuff. So now they said from the state side that 2009, the rules of 2009, IT Act 2009 rules, wherein they have rule number 13. It says, it orders the the organization, the intermediaries, the social media organizations to give the encryption key to the government whenever they ask for it. So I'll just request everyone to turn to IT rules 2009 once and look at rule number 13. Kailashi ji, give me a thumbs up when you have rule number 13 in front of you. Okay. So rule number 13 is intermediary to provide facilities, etc. The officer issuing the requisition conveying direction issued under Rule 3 for interception or monitoring or decryption of information shall also make a request in writing to the designated officer of the intermediary or person in charge of computer resources to provide all the facilities, cooperation, and assistance for interception and monitoring of decryption mentioned in the direction. So 13 says that whenever you are asked to provide the key, the decryption technology and everything, you will facilitate. Second says, on receipt of the request under subrule 1, the designated officers of the intermediary or person in charge of computer resources shall provide all facilities, cooperation, assistance, the same thing. Any direction, and this uses the word shall. They don't have a choice. They have to do it. Third one says, any direction of decryption of information issued under Rule 3 to intermediary shall be limited to the extent the information is encrypted by the intermediary or intermediary has control over the decryption key. Now, obviously, whatever you have control on, you're going to share with us that. So, seems to be reasonable. Along with this, state also cited section 69 of the IT Act. So, we'll go to 69 also. Kailashi ji, give me a thumbs up when you have 69 in front of you. Okay. Okay. So 69 of IT Act says power to issue directions for interception or monitoring or decryption of any information through any computer resource. Basically, this also gives the central government and the state government the power to order the organization, the intermediary, to facilitate the decryption and encryption facility, everything that is needed to find out who was the first originator, find out who committed the crime which has been committed, and everything else that is needed. Now, in reply, the organizations, the Facebook, which was being represented by Mr. Mukul Rohatgi, they came forward and said that while you are seeing this rule 13 of 2009, you also need to see definition 2G of rules 2009. So turning to the definitions, that is section 2 of the rules of 2009, 2G says decryption assistance. 2G says decryption assistance, which means any assistance to allow access to the extent possible. So this is where they brought the things to, that the decryption assistance means that we will only provide assistance to the extent possible. जहां तक हम जा सकते हैं, जितना हम कर सकते हैं, हम उतना करेंगे आपके लिए. We cannot do things that are impossible. So basically, Facebook said, WhatsApp said that, we also don't have the key to know what message was sent or what message was received. And so what is the possible extent? We can only give you, the means to reach the person, or means to, we can only give you the tech. Uske aage, if you think you can decrypt it, you decrypt it yourself. We cannot help you with the key or make a backdoor for you so that you can, at one front, we are telling our users that your data can only be viewed by you and not even we can look into it. But when the investigative agencies ask us, we make a backdoor and we can find out who was the person who has sent the first message. So they also cited maybe the government of Tamil Nadu and Madras is naive and innocent, and they are good and they are all good, and they'll not harm anyone with this kind of backdoor provided. But we are not sure of the governments to come. And if this is done for you, then anybody who comes into power, they can become arbitrary and they'll want us to do everything that we don't want to do, because users will lose their privacy and we will lose the users. So no point in doing this. There is no, foresightedness in this. So this was the contention.
It goes against the grain and principle of privacy on the whole, right? And it doesn't provide a level playing platform. Then the idea is also, at the end of the day, that anonymity is not bad, as long as it's not anonymity that is provided in a blanket manner either. So it has to be viewed from a wider prism and based on circumstances that are before you, before you provide any of these tools. So backdoor entry is something that governments and agencies have been asking for very, very long period of time. So this is a very, very significant judgment for that matter.
Right. So this is what it came to, and at this point, court said, okay, this is not what we can deal with. This is a very, very huge issue which is going to affect lakhs and lakhs and crores of people. So we'll not deal with this. We'll transfer this petition to Supreme Court. Same way, the Tamil Nadu government also said that yes, we cannot deal with this. We'll give this to Supreme Court. Supreme Court offhand said that Aadhaar ko to link nahi karenge. Aadhaar should not be linked to social media, does not make any sense, and it's just not compulsory, unnecessary hassle for everyone, for users, for us, for the social media, for everyone. Now they said that yes, we can talk about the traceability issue. So yes, we need some tech to find out who was the first originator of a message. But can that be done without being too intrusive and too invasive? That is what Supreme Court has been talking about in this case law from now onwards. So what happened was that all this debate happened. All this was put to Supreme Court. Supreme Court went to the IIT people and asked what can be done. They sought advice from them. There is one professor Kamakoti from the IIT Madras. What he said was that what can be done is that these organizations can put in a tech whereby if a message is forwarded multiple times, after certain number of times that it is forwarded, the number of the originator and the vital information of the originator will be put into the message in an encrypted form, to which the decryption key can be provided by the social media organization. So anything bad that happens, anything that is an offense, if it is found out that something like that is happening, then these organizations can provide us the key. We can put in the key, we can find out the vitals of the person who has originated the message, and then we'll come to know and the crime will be solved. That is one thing that can be done. Now, then came another professor from another university, which was IIT Bombay, Mr. Prabhakaran, who was brought in by the social media giants. He said that Mr. Kamakoti is not very far-sighted, and this will, in the long run, become a bad habit for the government and a bad habit for the investigative agencies. So we cannot provide that. We cannot provide that backdoor. For this to happen, we'll have to weaken the encryption to encryption, end-to-end encryption technology, and we'll have to install a backdoor, which is going to, break the spine of the whole privacy thing, which was put up in the Aadhaar case, the Puttaswamy case, and everything. And that cannot happen, and that should not happen. Now again came Kamakoti. He said, no, you don't have to completely break it down, and you don't have to, just weaken it totally to the roots of it. It does not have to happen. And then he suggested another thing. He said that, okay, let's do one thing. Whenever there is a multiple forward of a message being done, wherever the message is changed, we don't have to go to each and every person who has entered into that chain of messaging. Wherever changes were made, wherever modifications were made by any person, that person will become the originator, and we can only reach out to that person from a certain point when we find out that a crime has been committed. So if we find out that certain messaging is being done because of which certain crime is being committed today, so we'll go back to the person who made the last modification to the message, and we'll come to know who is the original, the first originator, and that person will be implemented and that person will be investigated. So again, this was challenged by the social media organization, and they said that this is obviously not very smart, because if you are going to the person who made the last modification, those who are committing crime, they are also smart enough. They'll make modifications, बार बार वो modifications करेंगे, and non-technically they can easily tackle this way of doing things. So this again fell flat. Now, another suggestion came that why don't we have a public key and a private key? Let's have one public key, one private key. The private key will always remain secured with WhatsApp. WhatsApp doesn't have to share it with anyone. We'll make an independent organization who, when things that such investigation has such investigative step has to be taken against a crime which qualifies to be a serious enough crime that we need the private key and the public key to come and the data to be decrypted, there we will do it, not otherwise. And proper permission channel will be there, proper orders will be given, only then it will happen. So this was one suggestion where court was a little okay with it. ठीक है, this can happen, but we'll still think about it. Now, what court said was, it said a lot of things, that privacy is article 21, it's liberty, the person, we cannot do anything which in the long run will turn into a menace for us, which cannot be controlled afterwards. Once the data is there in government's hand, it's not going to go out anytime, and they'll know everything, and they'll be able to control everything. So the criticism that is happening, the freedom of speech, everything will come under the radar and everything will be impeded. So a lot of debate happened on this, and they said that we are not sure if we can implement this suggestion. What we'll have to come up with is something that qualifies the test which was laid in the Puttaswamy judgment. Now, Puttaswamy judgment mein, what was the test? The test was that first there has to be sanction, proper sanction behind anything that you do. Second, there should be necessity. It has to be necessary. So, you can only sort of tickle the privacy front only when there is the need for it and it's a necessity. And the action that you take to find out what's happening or tackle the situation, it has to be proportionate to the necessity. And thirdly, there has to be procedural guarantee, which was the most important point. There has to be procedural guarantee somehow that this will not turn into a menace, the government will not turn arbitrary, and this will not go against the privacy of the users. So, and also one of the judges also cited that it is not just the state who can become arbitrary and can misuse it, it is also the non-state actors. So we also have to be careful that we should not forget the national interest while we are talking about the private interest of the individuals. And because of that, public should not find any difficulty, or they should not get into क्योंकि cyber terrorism we have cyber terrorism, we have non-state actors who are using it for funding and frauds and everything. This is also happening. So we have to take care of the society ka interest, and we have to take care of the individual interest also. So we have to keep all this in mind. We cannot shun everything that government is saying away at once, and we cannot totally just look over the privacy front also. So after this, Supreme Court has just remained silent. They have maintained status quo, and they have not talked any further on this case per se. We are yet to see what they have to say about traceability, and then we'll come to know what happens. Now we come to the OTT rules, which were mentioned in this case. So we'll try to understand which were the important ones that we need to know about, and let's see. So first of all, before we go into OTT, we'll have to understand what is OTT. OTT means over the top. Now, over the top means it's not something that is coming to you through channels. It's not something that is coming to you through government. It's not something that is coming to you through desks. It is coming to you through internet, and you are the one who can access it without anyone's permission, without anyone's intervention. You don't have to talk to the cable guy. You don't have to get a Tata Sky. You don't have to go to the government for seeking access for it. It is over the top. It comes to you through internet, and internet is free for everyone. So whenever you get something like that, it is over the top content. So over the top content comes to us through WhatsApp, Facebook, Netflix, and all these platforms jahan pe we can get access through internet. This is OTT. Now these new rules came into force, came in the year 2021, and they were meant to supersede the earlier rules of 2011. So the last time that we made rules, uh, you know a compilation of rules for the platforms and all these internet entities to follow, it was in 2011. But that time the scenario was very different, and 2021 the scenario is very different. So these have now become very exhaustive, and they have also taken into their ambit all the intermediaries and significant intermediaries. I'll come to what are these. And so now what happened, they were supposed to supersede the rules of 2011. So they have two purposes. One, accountability of the social platforms. What happened was the toolkit case. There were many messages going, making rounds on social media, jisme fake news was being circulated, and it was harming the government, it was harming people also, and many frauds were happening. Social media could actually use the algorithm and show more about the information that certain party had asked them, or talk to them about. He showed this, show that. Jaise right now it's being um, this is, some people say that in the Ukraine and Russia war, the violence that Russia is doing is being shown. And whenever there is some violence, something sad that happens, it is amplified on social media. And when there is something that the Ukraine does against the Russian army, that also gets amplified. So they are trying to show the Russia in bad light and Ukraine in good light and everything. So something like that. They're saying that social media giants, they can actually manipulate the algorithm, and they can manipulate the kind of news that we are seeing. They can manipulate the number of people seeing the news, and that is why there has to be some accountability of the social media platforms. This was also dealt with in this Antony Rubin's case, where court said that we cannot leave it to the social media platforms to determine whether a content is legal or not, whether it is going to harm the security and integrity of India or not, whether it is going to be in interest of the unity of India or not. So we cannot leave it to social media, of course. These are external organizations, and if we let them rule the information in India, then they're going to rule India. So we cannot let that happen. So first objective was accountability for social media platforms. Second was a redressal mechanism for people. So whenever we are on social media, we many times we get trapped into things that that are being misrepresented. So what happened recently, one of my friends, he went on to some Instagram page, or some Instagram page ka ad popped up on his Instagram feed, which said that you can buy a Canon DSLR for 3,500. And he, I don't know how, he's a smart guy, but maybe he just wanted to test his luck. He actually went on to that site, which was a very fake site. देखने से पता चल रहा है. He went on to that site, and he bought that Canon ka camera, and he only bought it. Nothing was delivered to him. He waited for like 10 days, 12 days. And then he told me after like 10-15 days, we are very close, we share everything. So he said कि यार मैंने शायद अपना बेवकूफ बनवा लिया है, but I'm just hoping that camera gets delivered. I have paid 3,500, so we were sure that nothing's going to come. So all these things, we don't have a redressal mechanism. Now you have paid for the Canon camera, but it's not been delivered. You don't know who's behind the page that you engaged with. Who do you go to? The policemen, they don't know anything about social media. You don't have any one person that you can go to who can help you with the problem. So where do you have to go? आप किसकी शक्ल देखोगे ये आपको नहीं पता. That is what these rules wanted to come up with, that you give a 3-tier redressal mechanism so that people are empowered and they feel secure that if something goes wrong, we have someone that we can go to and someone who will take our complaint. And that someone is going to be a grievance officer. Now, grievance officer in the OTT rules in IT Act is the most important person. He's the one who will be connecting the users with the nodal agency, with the second level mechanism, which is the self-regulating bodies, with the oversight mechanism, which is the ministry. So he's in the middle of it. He's the one that we have to reach out to, and he has been, put some stipulations on that he will have to acknowledge a complaint which comes to him within 24 hours. He'll have to act on it within 15 days. If that does not happen, one can appeal to the self-regulating authority in level 2. If the self-regulating authority doesn't resolve your query in 15 days, then you can go to the oversight mechanism. So this 3-tier system has been made for the publishers, for the users who get duped or they get misrepresented with information, and they kind of buy Canon cameras from these kind of sites. So this was the basic thing. This power to frame the rules, if anyone's interested, it is section 87 of the IT Act, where government gives itself the power that we can make any rules anytime. That is why you will find in IT Act, you have around 14-15 rounds of rules. So there are rules starting from 2001, 2003, 2009, 2011, 2015, 2000. So they are making rules. All this is happening under section 87(2) of the IT Act. Now, why do we need to regulate OTT? I've already discussed a little about it, but some succinct points. First, we are the largest open internet society. So China is closed society. America is not bigger than us, and other huge countries, Canada, Russia, all these people don't have the kind of population that we have. So we are the country which has the largest open internet society, and because of that, there are challenges also. तो वैसे ही हम देखते हैं कि many times government puts curbs on the access to internet in many states. Like it happened in Jammu and Kashmir, happened in Punjab, it happened in the northeastern states, it happened in West Bengal once, it happened in the Lakshadweep when the administrator was put. So all this has to happen when there's a large open society which has everything free for them to access, and they can upload anything, they can publish anything, they can use anything, they can comment on anything, they can share anything. So in this society, we need to have proper mechanism, proper oversight, and proper control of the government or any other organization. So this curbing of internet and blocking the access and intercepting information, this happens under 69A and section 69 of IT Act. So section 69A tells you, gives the government power to block the access of internet, and section 69 gives the power to intercept information which is being sent from one place to another. Second, because what's happening is corporate rivalries have come into picture, and many of these organizations, say suppose Tata versus Reliance, they both were trying to make way to Facebook and Tesla, trying to collaborate with the company. And in that, in doing that, on social media, we started seeing many posts coming against Reliance, against Tata. So they are being shot from one corporate towards the other corporate कि इनका नाम डुबाया जाए, इनको थोड़ा सा इनका शेयर कम किया जाए, या इनकी इमेज खराब करी जाए मार्केट में, so that the tender or whatever collaboration they can bag it. Third, there is fake news, malicious, anti-national news that is going on. That is, one thing that is always going on. Then there are communal riots because of these messages. Then there are financial frauds that are happening, of course. And then there is terrorism. That obviously is one thing, because there are these intermediaries like Facebook, social media, Facebook, WhatsApp, Instagram. These are being used by the terrorist organizations to honey trap people. Many times happens with the army also. They try to siphon information from them and then they use it against the country. So that is what is causing loss to us. Now, because of all these things, first time that this discussion rose was on 26 July 2018 in Rajya Sabha, when uh, an attention notice was brought in that we need to talk about all the menace that is going on, because in 2018 there was a lot of 2018 tak, 18 tak to the Modi wave was going on. So everyone was very happy with the government. After 2018, they started taking steps which were not very fine with people. They were against privacy. They were against the economic interest. They were against the religious interest. They were against, sects, and a lot of things were happening. That is why a lot of uproar came against the government. उसके बाद हमारा farmer वाला thing भी हुआ. So in these 1 or 2 years, the attention was sought towards making OTT rules and trying to control the the social media giants. In 2018, December 11,
And digital publishing agencies as well. And publishing was also covered within these rules.
right, and in 2018, some of the very very disheartening rape incidents also happened, because of which Supreme Court in one of its judgments on December 11, 2018 said that we need to make guidelines on pornography, rape, sexual content, and all these things, and especially social media has to be brought in control. Then there was toolkit case which happened, which again was a hype. And after that, on 24 September 2019, Supreme Court finally ordered the central government to make a timeline, to apprise them of a timeline, that this is when you will be able to complete the rules for the IT rules for social media. So the government said that yes, we'll be able to do it by January 2021. Then came an ad hoc committee of Rajya Sabha on 3rd February 2020, which started making all these rules. And February 2021, it was 25th February, 26th or 25th February of 2021, that these rules came, and they give 3 months time to the OTT platforms to, start pulling up their socks and try to uh, become compliant of what is being floated as rules here. So now, what were the rules? We'll just go through them. Before going into the rules itself, first we turn on to 2021 ke rules. I hope everyone has IT Act and 2021 rules. We'll just look at few definitions so that we understand what we are talking about in the rules. So first definition is access control mechanism. Now, as the name suggests, this is the kind of control mechanism that these social media organizations have, and they can actually control who is accessing what information on their platform. Then this was 2A. Then comes 2E, which is committee. Committee is the interdepartmental committee that I was talking about, the committee that you can appeal to, or the committee that you can refer the case to when you don't get proper redressal from the grievance officer. Then comes 2H, which is content descriptor. Now, content descriptor is when we go and watch a movie, or we are watching it on Netflix. There comes a little page that tells us this is this should not be viewed by children under 16 years of age, or 14 years of age, or 13 years, 7 years. There are different categories: UA7, UA13, UA16, and they will give a descriptor that there is violence, there is pornographic content, or there is sexual content, or there is all that their nudity, language, sex, violence, fear, threat, horror, and all of these things. So you have to give this kind of descriptor.
Correct, which didn't exist. Content filtering didn't exist in this manner. And now, if you see on Netflix, for example, on the top left corner, the rating will also be displayed, and it will also tell you why is that rating been given, whether it's because it's violence or sex or abusive language that is being used, explicit content is being shown in some way, which way or the other. So these are all the reason these little things have come into the picture and changes are being made is because of these rules having been promulgated and put into force.
Right.
Sorry, I just thought.
No problem, sir. So what you see on the screen is exactly what I'm talking about. So this is universal, under age 7, then 13, 16 years, and then adults. So this has to be the content descriptor that there has to be. This is 2H of the 2021 rules. Then we come to 2021 rules ke 2IP, which is digital media. We all understand this term. We'll just read it. It means digitized content that can be transmitted over the internet. That is what we need to know. So whatever content we see on internet which can be transmitted, which is digitized, which is audio visual, that is called digital media. Then we have grievance. Now this is grievance includes any complaint, whether regarding any content, any duties of an intermediary. So this is important. So grievance is not only your grievance as to what content you are seeing, or that the content that you're seeing is disturbing or in any way anti-privacy. The complaint, it can be a complaint whether regarding any content, any duties of the intermediary. So all the duties that have been stipulated on the intermediaries through the IT Act and the IT rules, OTT rules, or the publisher under the Act, or other matters pertaining to computer resource of the intermediary or publisher, as the case may be. So you can be aggrieved by these things also, and you can file a complaint regarding all this stuff also. It's not just your complaint regarding content. Then grievance officer is the officer appointed by the intermediary or publisher. So let's not get confused between intermediary and publisher. When we say intermediary, we are talking about a platform which helps two people connect with each other. So when we are talking about WhatsApp, it is an intermediary. Me and Arvind sir can connect and talk over WhatsApp. So that's an intermediary between us. Yes, sir.
So intermediary does not only mean that it facilitates communication, but what it does is facilitates the access to a platform which allows multiple activities to take place. Okay, on a large scale, wherein it allows multiple people to sort of carry out those activities by accessing the platform that it is created, essentially.
Right. That is intermediary. And then there is a publisher. So publisher is essentially an organization or a company or any entity which is putting out or doling out information on its platform and trying to, for example, Lawyers Club India is a very good example of it. So we are publisher as well as intermediary. So when you look at Lawyers Club India, when you go to the articles and judgments wala part, we become a publisher because we are doing the current affairs, current news, legal news, judgments, and all that. So we become a publisher there. And when you go to the forums part, there you can talk to lawyers, talk to litigants, talk to people, get connected, exchange messages and everything. There we become an intermediary between two people who can exchange messages.
Also, because you're an education platform, you are an intermediary as well as a publisher, because you're publishing content, and that content is also in a repository which is accessible by people.
Right. So that is a basic difference between intermediary and a publisher. So this will come handy when we are talking, when we go into the rules. Then there is Q, 2Q of the 2021 rules, which talks about online curated content. OCC. Online curated content means any curated catalog of audio visual content other than news and current affairs content, which is owned by, licensed, or contracted to be transmitted by a publisher of online curated content and made available on demand including but not limited through subscription over the internet or computer networks, and includes films, audiovisual programs, documentaries, television programs, series, podcasts, and other content. So online curated content is whatever that we have control on, the content that we have control on, and that is what we are transmitting to you. So this course is also an online curated content. We are curating content audio visual for you, and we are delivering lectures. Similarly, when you are watching a movie on Netflix or a series or a documentary, that is also online curated content. When you are reading something, that is also online curated content, if the organization has a sort of access and control on it, and after proper curation they dole out the information to you in whatever form they are doling it out.
That's why YouTube would also fall within that sort of definition of online, or an online curated content provider is what they would be termed as.
Right.
So yeah, good one.
Right. Then we come to 2S, which is publisher. Publisher, I've already told you. Publisher means publisher of news or current affairs content, or a publisher of online curated content. So we have already understood what is online curated content, and we already know what is news and current affairs. So whoever is publishing all this is a publisher. Then we come to 2V, which is significant social media intermediary. Intermediary, we know it connects two people. Social media intermediary, where socially people can come and exchange media, and that platform is a social media intermediary. When we say significant social media intermediary, it is a social media intermediary which has more than 50 lakh users on it. So most of these platforms that we are using, for example, WhatsApp, Twitter, Instagram, Facebook, all these are significant social media intermediaries. Why they have explained significant social media intermediary, publisher, and the intermediary separately is because they have separate rules for themselves. So these intermediaries have the lowest level of rules, lowest number of stipulations. Then will come the significant social media intermediaries, which have additional compliances to make. Then will come the publishers, who will have to make more compliance, because obviously first the intermediary, they might be some organization like Lawyers Club India. We have around 10-11 lakh people, so we are not controlling a very huge part of the population in India. So we are only intermediary, so we don't have to be controlled much. Then significant social media intermediary, because they have 50 lakh plus people, they have some additional compliances, but they are not actually the ones who are actually themselves creating content for people. That's why a little less control than publishers. And then there are publishers who might be a comparatively better weapon than the other two entities against the government when they are publishing content on their platform. So that is why most of these stipulations, most additional stipulations are on publishers. That is why they have made these categories: intermediary, publisher, and significant social media intermediary. Then we come to 2W, social media intermediary. I've already told you, means an intermediary which primarily or solely enables online interaction between two or more users. That is what is important. And user, we already know. User account, we don't have to go into. So this was what we had to know. Now we deal with the rules very quickly. Anyone who wants to go to the sections that I'm referring, you can go to them later, or if sir allows, then we can go right now also. But I think I've already taken a lot of time. So we come to part 2, which is the OTT rules. This is rule 3, due diligence by intermediary. So a normal intermediary, what all do they have to do? First of all, on their site, they have to publish prominently that what are the privacy rules on our site, what is the agreement that the user is making with us when you come to our site and consume our content. That is the first duty. Second, they have to inform the, yes sir.
So these are privacy policy and terms of use, which are very, very important.
Right.
And there, it is a stipulation now that you have to publish both these documents. And these documents are very, very carefully drafted, at times. So, as a what we can do is, Raghav, we can also pull out like a terms of use and a privacy policy and probably share it with everyone, because that will be very, very helpful. Because this
Right.
is what you all will be compelled to draft at some point when you are sort of advising people who want to set up different platforms. So this is a very important thing that Raghav is talking about. Thanks, Raghav.
No, most welcome, sir. Um, so yeah, so the second sub rule of rule 3 says that you will inform your users that do not host, display, upload, modify, publish, transmit, store, or update any information. So you are kind of warning them that these are the things that you don't have to do. For example, on Lawyers Club India, what we do is we have an automated system that if someone's talking about sexual stuff, someone's abusing, or someone's talking about things that people are not very comfortable talking about, anything that is meant to be attributable to terrorism or something like that, it does not display on the site right when you upload it. It first comes to us, then our editorial team will look into it whether it can go or not, and then it will go. So
So this is in simplified form referred to as content moderation, which is also the duty of an intermediary, which is one to inform you that there are certain, so in the terms of use which are provided and published on the platform, usually what Raghav is talking about right now is also cited in there, wherein it will say that you have to conform within the rules that have been created for the platform, and it cannot be allowed to perpetuate any kind of negativity at any point. And that is why content moderation becomes the intermediaries sort of compliance mechanism as well, wherein they have to ensure that no one is inciting violence or inciting or inciting or making statements which hurt the religious sentiments, or they are not sexually explicit, for example, or disseminating any data which violates somebody else's rights. So those are generally are in the terms of use that Raghav was just talking about, and I mentioned.
right, sir. So what all things that users don't have to do, or what are the things that you don't have to publish about or put anything, upload, modify, ये सारी चीजें आप नहीं करेंगे if it is attributable to all these things. There's a list of things that has been given. So um all these things, like sir has repeated many times, all these things that happen in the real world, in the physical world, on the field, that is the only thing that is happening on internet, just through internet. So every offense that we have in IPC, all those offenses are being covered here. All that you don't have to do using these intermediaries. So first of all, if something belongs to another person and to which the user does not have any right, that means plagiarism and theft. So you don't plagiarize content, you don't steal from other websites, which will come under 378 of IPC, which is theft ka provision. Then when you're talking about privacy, you will go into 71 and 72 of IT Act. 71 and 72 of IT Act will talk about privacy. Then it should not be defamatory. Again, we find provision in IPC 499, 499, 500, 501. That's what that these are the provisions about defamation. Then there should not be any obscene content. On obscenity also, we have offenses, physical world of offenses, which are 292, 293, 294 of IPC. Then comes pornographic content. Pornographic content ke upar we have POXO Act. POXO Act के अंदर also we have a separate chapter 13 section 13 14 15, I don't know which chapter it is, but section 13 14 and 15 of the POXO Act, they talk about pornographic content, and pornographic content where explicitly or implicitly you have included a child or you have morphed images or something like that. Then
Child pornography and POSCO is actually prevention of sexual offences or within a workplace environment is what it is in its essence.
yeah, workplace environment wala alag ho gaya. POXO will be the protection of children from sexual offences.
Protection of children, and that's where, look, something else which I had also mentioned in the past, which was that there is a lot of work that is being done by a lot of these bigger companies which run into which fall within the bracket of being called an intermediary to block pornographic and negative content, and they have content filters that are running in the background all the time, especially to catch instances of child pornography or human trafficking and etc. So sorry.
And that is also there in one of the rules in these OTT rules, that you have to have some automated tool or mechanism so that you can identify if anything like this is coming on your site, and you have to remove it or you have to handle it like you have to. So definitely there is that. Then pornographic content, pedophilic content, that again is when you have pervert intentions towards children. Then you have invasive of another's privacy. We have already talked about privacy. So if you are intruding into privacy of another person, then obviously it goes against the fundamental right. So you go against Article 21 of the Constitution. If the entity which has to protect your data, for example these social media giants and all that, they are unable or they fail in protecting your data, then they come under section 43A of IT Act. So उनके ऊपर भी पेनल्टी लग सकती है, 5 लाख रुपए की पेनल्टी है. The person who is a managerial person or who is responsible for the protection, he might go to jail for 3 years. So heavy penalty in IT Act 43A. Then nothing that includes bodily privacy, which means voyeurism, like someone who you find it in IPC also 354C, which talks about voyeurism, where if you were watching somebody or making a film of somebody in a position or in a place where that person is not expecting anyone to eye them, then you are committing voyeurism. So similarly here you cannot upload or publish or transmit, store or update any content which is against or includes bodily privacy of another person. Then
Sorry, Raghav, a good example of this, and there have been several cases, are where people have filmed others, and publish it on these pornographic websites, which is termed to be as revenge porn. And that is what the this particular aspect is tried to cover as well, for that
right.
matter.
So
And revenge porn has been outlawed because it not only outrages the modesty of someone, but it also causes multiple other harms. Is what these acts have recognized, which is why there's a whole fervor behind the building the legislation behind sexually explicit sexual offenses, essentially. And there is a lot of talk about why it ought to be gender neutral. It is not only that one gender gets targeted, but multiple genders get targeted, and that is what the world is slowly beginning to realize and understand, and that is where the progress is taking place now. So recently there was a judgment of the of Kerala High Court, if I remember correctly, wherein the marital rape was finally recognized to be a part of and as an offense. So and then there has been a very stupid judgment by the Delhi High Court recently, where they've completely vitiated that progressive aspect of how the Kerala High Court recognized marital rape. But yeah, I'll look that up again and I'll tell you why the Delhi High Court has been silly in the way that it's interpreted certain things. Which is
I did actually read through that, both of the judgments, and well, they have point. They have a point there. Marital rape, which in 376 ka explanation too, वहाँ पे marital rape is not an offense as of now until and unless your wife that you are committing rape with is a minor. But there is, you know, uh, Miss Jacob, Miss Jacob, who's from the side, who's from the prosecution side, and Mr. J. Sai Deepak, equally excellent lawyers who are arguing from both the sides. And the very basic foundation of it is that Miss Jacobs, she says that it's the fundamental right, and when you are giving right to a prostitute, when a prostitute can be raped, and an offense can be made when you are raping a prostitute, would you put your wife on a pedestal lower than a prostitute when you say that an offense is not made when you are committing a marital rape with the wife? So that is what Miss
very
Jacobs says.
bad analogy in my opinion. But what essentially what they're trying to say is, if the concept of consent is recognized, okay, in multiple instances, and it is playing such a big role, especially in the context of privacy, then why is consent not considered to be a form of an acceptable practice within the confines of this particular activity that takes place, and it's considered to be offensive by nature? So
Right.
on what basis are you saying that marriage leads to the consent that you will have full right over my body and mind and etc., which is not the case, right?
Hmm.
Marriage is
So
just a
that's what
union
that's
of
what yeah, that's what the state also cited, that we concur with the consent part of it, because they have adjudicated in the Joseph Shine's case, when they ruled out adultery. They said that women is not a chattel of the man, so adultery was ruled out, and they concur on it. But on the other side, what they say is ki if we bring this into the into force, marital rape, then the institution of marriage will not remain steady, and there will be no evidence, cogent evidence cannot be brought. And without that, just as the many of the legislations are being misused, this one will also start being start to being misused, and that's what will happen. They are
any
just apprehending
legislation,
that.
yeah, any legislation that comes into the picture is going to be misused at some point. The fact of the matter is that it needs to be sort of formulated correctly. And there have been multiple instances of where people have, including the Law Commission, has beautifully framed certain things which have not been adopted altogether. So I think these are all redundant arguments, in my opinion. But it's time to
Complicated.
see a progressive evolution of how we view these things from a more holistic perspective, as opposed to it being ensconced in the fact that if there is no penetration, then it doesn't amount to rape, which is another issue for that matter, or there is no sexual offense that is committed there. So that will also pose a problem at a later date, because our laws are archaic. They were devised in the 1800s and the 1900s, for that matter, where these things were viewed absolutely very, very differently, and we have that is the reason why it's referred to as a colonial hangover, right? Because we're still sort of referring to principles that were devised according to that time period, and we haven't evolved from there in our applicability. And on the one end, we're talking about technology and evolution and all of that, but at the other end, we're very, very archaic in the applicability of it. Sorry, I
Right.
didn't want to digress, but I thought this was an interesting segue to take from here. And
Right. Okay, so coming back, next one is harassing on the basis of gender. So you are already protected under Article 14 of the Constitution, that you cannot be discriminated against or anything that should happen on the basis of your gender. Then there is libelous content. So you are defaming someone, again comes under defamation. Racially or ethnically objectionable content. This you will find in 153B of IPC, where if you were you are delivering a speech in some public area where you are asking people to meet somewhere and go against Muslims or Hindus or Christians or Jews, that is when you go against racially or ethnically objectionable content, and that is what you can do through uh, internet also. That is why this has come in the picture. And gambling, of course, and otherwise inconsistent or contrary to the laws in force. And there was one insulting that I left. Insulting can also be, we can find offenses regarding insulting in 504 of IPC, where if you insult someone to create breach of peace, then you are punishable. So next one is, it is harmful to child. We've already seen POCSO ke andar we have a lot of law about it. Then infringes any patent, trademark, copyright, proprietary rights, that we are going to read about. IP laws we already know a little about. So if you were infringing the copyright, you're using someone else's music, someone else's content, then you don't do that. That is one of the duties of intermediaries, to inform the users. If it violates any law for the time being in force, any law, if you deceive or mislead the addressee about the origin of the message, or knowingly and intentionally communicate any information which is patently false or misleading. So deception again is sort of misrepresenting, forgery, cheating. So 463 forgery, 420 is your cheating. And in the IT Act, you will also find 74 of the IT Act, where you will find offenses relating to misrepresentation and misleading, and 71 also. So there are many aspects, like electronic signature आपने गलत दिखाया, आपने electronic signature certificate कहीं पे गलत दिखाया. So these are the kinds of deceiving and misleading you can do with regard to the internet stuff, the cyber stuff. So 74 and 71 of the IT Act deal with misleading in the IT Act, internet, and in IPC you'll see misrepresentation and deception and forgery and everything. Then impersonation of another person, you'll find it in IPC also, 419, where you'll find cheating by personation. And you'll find it in 464 ka second part also, where you sign or seal or affix any kind of initial and try to make the other person feel that you are some other person that you're not. So that is what is covered under IPC again. Then it threatens the unity, integrity, defense, security, sovereignty of India, friendly relationship with foreign states, public order, etc. Public order you'll find in Article 19. So it is one of the restrictions in the Constitution against the right to speech. So it's not absolute. You can be proceeded against if you are going against the public order, unity, integrity, and all these things. Then if whatever content you are using on the site contains software, virus, or other computer code or file that is programmed to interrupt, destroy, or limit the functionality of the computer resource, obviously you cannot do that. You should not do that. Something that is false or untrue, again misrepresentation, and which is done to mislead or harass a person or for financial gain, that means you come to extortion. So that is 383 of IPC. Now after this is kuch gine chune hai that I'll just tell you about. You can read them on your own and we'll wrap this up. So next one is 3D, where if the intermediary receives any knowledge about any content that is not cool, that is not lawful, and there's an order by the government that you have to remove it, then you have to remove it. Then comes 2F, that there has to be monthly review or monthly reporting of whatever is happening, how many complaints you have received, how you have tackled them, everything like that. Then comes 3H, where in case someone comes to your platform and registers and then withdraws, you have to keep the information of that person for at least 180 days. 6 महीने के लिए आपको उसकी information बचा के रखनी है, because there are many people who come to a platform, they will dupe people or they'll extort from people, they'll mislead people or they'll threaten people, and then they'll delete their ID. So intermediaries के ऊपर ये ड्यूटी है कि अगर ऐसे कोई रजिस्टर करके विड्रॉ करता है, you don't let go of the data of that person, you keep it for at least 6 months, so that if there is any crime that the person has committed, the person can be investigated against and proceeded against. Then comes 2I, which is all the measures that should be taken to secure the computer resources. So obviously you have to maintain security. Then comes 2K, which says, this is important, you shall not knowingly deploy or install or modify technical configuration of computer resource or become a party to any act that may change the potential to change the normal course of operation. So when we were when we were studying the 65B certificate in Indian Evidence Act, one thing that it was focusing on prominently was that the ordinary course of working of your computer should not change. If it is in the ordinary course of working, then only you can bring the certification, and then only your evidence will be, it will मतलब उसको मान्य माना जाएगा. So if something or some technical configuration is there because of which the ordinary course changes, you should not install it. Then there is uh, I to L, sorry, where you have to report cyber security incidents to the Indian Computer Emergency Response Team, which you will find in 70B of IT Act. So you can read about the act there. Then there is grievance redress mechanism, and there is additional due diligence that has to be taken care of. I've already told you about 3-tier mechanism, which is the last thing that we have to know about everything that is there in OTT rules. Baki sari cheezein are incidental and ancillary. So redressal mechanism is a 3-tier system. First redressal mechanism, first level is the intermediary has to employ a grievance officer. So there's a grievance officer. Anything that happens, one person can go to the grievance officer and tell him that this is what has happened with me, and that grievance officer will take cognizance of it and try to help you with it. The second level is when there has to be an organization of the intermediaries. So say suppose Facebook, WhatsApp, Instagram, all these people, all these organizations, they have to make an organization and have to make a self-regulating body. So they'll join this self-regulating body and keep an eye on each one of them themselves. Everything is happening properly and grievance officers are working properly. And if something goes wrong within the self-regulating bodies also, then you go to the ministry, and there they will do, they have all the powers to do anything that they want to do. So that is the sarkar. So that is what is about OTT rules mostly. And I think, sir, I've already consumed all of the time that we had. So this is where I'll put an end to what I had to say.
Thanks, Raghav. I think you've covered pretty much everything that we intended on covering, but on mine was a fairly bit of an overview of all of this, because I'd already covered this in the first class that we had done. Very wonderfully presented, Raghav. Really enjoyed that. Couple of things that I wanted to highlight were that uh, internet. So when these rules were formed and the self-regulatory mechanism was put into place, the association that was formed, the self-regulatory association, was called the Internet and Mobile Association of India, which continues to exist, and there are about 17 OTT players and platforms who are a part of it currently. And I think where which is Airtel as well, which is kind of become a part of it because of and is a part of it. Sorry, and I get into discussions with them, and there's a lot of talk about regulation and what we spoke about, and how there can be new technological parameters that can be put into place for regulating and blocking specifically, because a lot of intermediaries receive, as Raghav had pointed out earlier, two things. One, that agencies, because they are authorized to do lawful interception also and lawful requisitioning of information as well. So because of these two reasons, not only our intermediaries have a very high compliance with respect to maintaining the data that is being disseminated on that platform and regulating content, but they also are compelled to give out information to a large amount of agencies. And that is why there's a stipulation on maintaining that data as well, as to how many requests have as an intermediary received, and what was essentially flagged, and things like that as well. So those are another couple of things that I wanted to mention to you guys. We've already gone through the classification of content, and there's obviously parameters like parental locks that are also offered, so that despite there being a content rating that is being given, you can also use these tools that have been provided to ensure that the content is also accessed only by a few, because these are all things that the law also realized were parameters and tools that need to be provided, so that the the there is an entire gamut of rules and regulations and tools and provisions to be able to put those rules into effect as well. That's the thing. A couple of other things. So of course, we also wanted to like sort of quickly run you all through the fact that these OTT regulations have also, been adopted, wherein we've looked at other jurisdictions which have adopted certain set of rules and regulations, and some of it you will find a lot of similarity when it comes to the other jurisdictions internationally that have regulations with respect to the OTT and etc. Right? So in Singapore, there is of course a content code, and that classifies the content and also provides guidelines with respect to how the rating is to be carried out, and how there are certain prohibitions on what can be published, what can't be. There is obviously a license mechanism that these platforms are required to obtain, which is obtained from the Infocom Media Development Authority, which keeps a check on any violences with respect to content and etc. Right? Which this is in regards to Singapore specifically. Australia is also there. Again, they also have these ratings that are globally acceptable. Each one has obviously categorized it a tad bit differently. M standing for mature. R is the universal rating for it being something which carries sexual content or violence or explicit content, and that because of that reason there's also an age categorization that is a tad bit different in some of these jurisdictions that have rules with respect to this. In fact, Australia also has something called the e-safety commissioner, who regulates this particular uh, and is a mechanism for redressal essentially, which is under the Broadcasting Services Act promulgated in 1992. In within which what it also says is Schedule 5 talks about the act which deals with the content that is hosted outside of Australia, and Section 7 within this particular legislation talks about content which is hosted within Australia. And this is obviously the legislation which talks about regulation of contents and the rules that surround the operation of these. So Turkey is another one which has got the Radio and Television Supreme Council, which talks about regulations and is actually an independent body. It issues licenses for a period up to 10 years, and it monitors visual as well as audio content actually. Saudi Arabia come within the domain of cybercrime laws. As you know, Saudi Arabia's rules are extremely stringent, and a lot of it is arbitrary, and they have a very different application actually in certain instances as well. So it's an interesting jurisdiction on the whole. England has always been supremely progressive. They've got the Department for Digital Culture, Media and Sport, which also released a paper specifying how OTT platforms are to be dealt with. And with that, we come to an end. If there are any questions for Raghav or I, please do let us know, and we'll take them up and try and answer them for you.
Right, sir. I think we don't have any questions as of now. And we've already consumed the time that we have. So we'll take questions in the next class. Right. So anyone, any question, you send it on WhatsApp and then we'll address it before the class that we start on next Sunday. And thank you so much, sir. Thank you so much, everyone. And I'll wrap it up right here.
Great. Wonderful presentation, Raghav. Thank you for taking us through. It really helped me and saved me from having to speak for the last 1.5 hours. So
Welcome,
thank
sir.
you very much for doing that. And thank you very much, everyone, for sort of attending today's class and taking off the time as usual. I hope you find this helpful and look forward to seeing you next time. Cheers and have a lovely rest of the Sunday.
Thank you, sir.
Bye.
Likewise.
Bye. Bye. Thank you.
Bye, everyone.
Thank you, sir. I am very unfortunate. Total power cut.
Oh, see you.